quorum being present, this town meeting is called to order. For the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, business under Article 3, Mr. Adams. Is Mr. Adams here? What was that? Oh, okay.
Mr. Moderator. Move that the town vote to amend the Reading zoning map dated April 8th, 2013 as referenced in section 3.2 of the Reading zoning bylaws, Reading zoning bylaw, and to amend section 4.9.2 planned unit development residential PUDR as follows.
Mr. Tafoya moves that we dispense with the further reading of the motion. Is there any objection? None appearing. Is there a second to the motion? Second, thank you. Ms. Dilios?
Thank you, Mr. Moderator. Article 13 tonight is before you, and it has to do with some modification of an existing PUD district. That's an overlay district. And I'll be running through the PowerPoint, but before I get to that, I'd just like to highlight what we're asking for tonight and give a little background. The developer of Johnson Woods approached us some months ago at the CPDC and requested some flexibility with a parcel that he acquired adjacent to this site. And so what I'm going to run through is showing you how we thought we might be able to work with him to basically come up with a way to move 4 townhouse units slightly on the site and still maintain the required buffers. In fact, he's got more than he needs for buffers. But it does require a zone change to be able to do that. So I'll run through exactly what that is. So Article 13 amends the Reading zoning map and section 4.9.2, the planned unit development residential district PUDR of the zoning bylaw. So as I mentioned, the developer would like to shift a few units to better use the existing site topography and save existing trees. To allow for the change, but to prevent the expansion of the PUDR, the CPDC worked with the developer on the proposed zoning change. The zoning change would allow the developer to move the units closer to the PUDR boundary and will provide additional vegetated buffer. So in this graphic, you can see what it is we're talking about. Johnson Woods is a 40-acre site. It's outlined in green, and that's located off of West Street. There are 193 housing units with a mix of townhouses and garden-style condominiums. And this development was permitted under the Planned Unit Development Residential District, or PUDR, which is an overlay district. And that's not the underlying S20 district, but the overlay is now a district that some of you might be familiar with in some of the other developments that have gone on in town. This adds flexibility and preserves a lot of the vegetation and so forth. So that's what we're dealing with. In this graphic, you can see the red is what's being proposed. So the greenish yellow is what has been approved. So essentially, we're talking about sliding units over to this boundary. So under the current zoning, and the reason this is before you tonight, is you really can't do this without a zone change. The PUDR overlay district requires a minimum setback of 20 feet. And there's some variation with another aspect of the site. And that setback, you have to preserve the natural vegetation. So, rather than just add that parcel to the existing overlay district, what we decided would be a better alternative is to create a new overlay district that preserves the setback requirements and adds the adjacent parcel. So this new residential overlay district is called the Planned Unit Development Residential Corona Overlay District. So that's a PUDRC. So it's a little bit different animal. That property that I was mentioning that he acquired, it's a portion of a lot that's comprised of about 26,000 square feet. So now this new PUDRC would be not only providing the 20-foot setback, but it would provide extra, and you'll see that on the next slide. This meets the needs of the developer, saves the trees, works with the existing topography, increases the vegetated buffer, but no buildings are allowed in this new district, in this new piece. So that was where the CPDC decided it was better to call it a different animal than just add it into the existing district. So we don't want to see more units. That's the bottom line. So the buildings shift to the PUDR boundary with a no-build buffer. And the PUDRC, this new animal that we're creating, is used only as a vegetated buffer. So this will address issues with site constraints and additional buffer from the proposed housing units. So how do we do this under zoning? Essentially, we are inserting new language in section 4.9.2, which will identify and define the purpose of the PUDRC overlay district. Again, vegetated buffer and offset area to the Johnson Woods development. No buildings will be allowed. The Reading zoning map will also be amended to identify this new district, the PUDRC. So a yes vote on Article 13 would approve this new creation called a PUDRC zoning overlay district. Thank you.
Bylaw Committee report, Mr. Crook.
Stephen Crook, Bylaw Committee Chair. At our meeting of November 7th, the Bylaw Committee voted 3-0-0 to recommend the content of this article.
Thank you. CPDC report.
Nick Safina, CPDC member. On Monday, September 23rd, 2013, the CPDC convened to hold a public hearing on the proposed Article 13 to amend the Reading zoning map and Section 4.9 Planned Unit Development Residential of the Reading zoning bylaw to adopt a new overlay district called Planned Unit Development Residential Corona District, PUDRC. All documents were made available on the town website. Public hearing was held to provide an opportunity for comment and to determine whether the provisions of the proposed Article 13 shall be adopted by the town. The September 23rd, 2013 public hearing was opened at approximately 7:45. CPDC opened the public hearing for public comment and no comments were received. Public hearing was closed that same night on September 23rd, 2013. CPDC voted 5-0-0 to recommend the proposed zoning amendment to town meeting.
Is there further discussion? Ms. O'Neill?
Mary Ellen O'Neill, Precinct 4. Could we look at the slide where it shows the red and green lines and the trees, please? Okay. Yes, this one. So he can move those, shift those buildings back right up to that line of the new proposed overlay district. But what is he going to preserve in terms of the vegetation on this additional lot? I mean, it looks like it's right up against, the buildings are right along it.
This entire lot would be a vegetated buffer.
He's committed to keeping all those trees there and everything?
Yes, in fact, one of the motivations for moving these 4 townhouses is so that he can preserve some of the trees. There's also ledge there that he doesn't want to get into having to blast and such.
Okay, thanks.
Further discussion? None appearing. Are we ready for the vote? Where? Oh, okay, sorry. Ms. Schneider?
Gina Snyder, Precinct 5. I just want to be sure I understood. So it says that the district is intended to serve solely as a vegetated buffer in one paragraph, in one section. And then in another paragraph, I mean, does that, it says it's intended. So in the zoning, you're going to have the statement that it's intended to serve solely as a vegetated buffer. Does that actually mean that it has to stay, or it's just intended? I'm not sure I understand.
Yeah, that means that it will be a vegetated buffer with no build provision.
And if the people in those buildings in the future say, well, we'd like a better view, they can't do anything to the vegetation?
This area in yellow is all vegetated buffer.
Mm-hmm.
Has to be maintained that way.
Okay, seems a little...
Is there further discussion? None appearing. Are we ready for the vote? This requires a 2/3 vote. We will try a hand count first, but then we'll proceed to a standing count if necessary. All those in favor of the motion, please raise your hand. Those opposed? And it is unanimous. Okay, motion carries. Business under Article 14. Do we have a motion?
Thank you, Mr. Moderator. Move that the town vote to amend the Town of Reading zoning bylaw, Section 4.2.2, Table of Uses, Section 1.1.3, Table of Off-Street Parking and Loading, Unloading Requirements, and Section 5.1.2, Table of Dimensional Controls, to establish reasonable regulations for exempt uses under Massachusetts General Law, Chapter 40A, Section 3, as follows.
Mr. Tafoya moves we dispense with the further reading. Is there any objection? None appearing. Is there a second? Second, thank you. Ms. Delios?
Thank you, Mr. Moderator. Article 14 is an article dealing with what we call exempt uses. This is a provision under state law, Mass General Law, Chapter 40A, Section 3. It's known as the Dover Amendment. And basically what the Dover Amendment says is if you meet the criteria for one of these exempt uses, a church, a school, a daycare center, then you can put those uses anywhere. If it's in a residential neighborhood, if it's in a commercial district, anywhere, you're exempt. Here we go. Exempt from what zoning regulates as far as use. So you can go anywhere. In the current bylaw, zoning bylaw, there's little guidance on how these uses are regulated when it comes to dimensional requirements and parking. We have provisions in the bylaw, but they are not specific to these exempt uses. Mass General Law, Chapter 48, Section 3 says that communities can impose reasonable regulations. That's what's before you tonight, to tie up that loose end. So essentially, these uses can't be prohibited. They're exempt. We've treated these uses and applications in what we call limited site plan review. And so CPDC has had some applications for this type of a review, but it's been challenging because we don't have the dimensional and parking standards to go along with it. And the building inspector then is in the unenviable position of making the judgment call of what parking is required because it's not specifically called out in other things. Just to note, the Reading Public Schools, as all town offices, are exempt from zoning requirements. So what we're doing here in Article 15 is amending the zoning bylaw to include dimensional controls, setback requirements, and parking requirements for these exempt uses. And as we heard from the reading from the CPDC, we're looking at amending the table of uses, the table of off-street parking, loading and unloading requirements, and the table of dimensional controls, looking at lot size, minimum setback, maximum lot coverage, and maximum building height. Again, these all come out of the statute. So the table of uses under 4.2.2 will be amended by including school and churches. These uses are, will be allowed by right in all districts, but now they're actually listed in our table. Then we go to the parking side of the equation, and this is our table of parking and loading and unloading. And again, we list them here. For schools, we have two categories. One for nursery, kindergarten, elementary. That's one space per each employee on the largest shift, plus one space per 7 students. For high schools, it's one space per each employee, plus one space for each 3 students. For churches, it's one space for each 300 square feet of gross floor area or fraction thereof. So 5.1.2, the table of dimensional controls in the zoning bylaw, that sets requirements for minimum lot size, minimum setbacks, maximum lot coverage, and maximum building height. In Article 14, we're looking at a new category of uses, exempt uses, and within that category, schools and churches. The front yard setback minimum is slightly reduced for these types of uses, and that allows a little bit more flexibility. The side and rear yards are slightly increased, and that's to protect, basically, neighbors. So the proposed amendment contained in Article 14 would make it easier for applicants to understand the requirements under zoning and streamline the permitting process. We're being clear, or we're really tying now these standards, dimensional and parking, to a process that we've already been following under limited site plan review. This is one of the goals of the comprehensive update to the zoning bylaw, which I mentioned Tuesday night we would be engaging in over the next year. The reason this is before you tonight is because we have really gotten tripped up on this in the past and felt that this really couldn't wait and needed to be addressed. So tonight, a yes vote will approve these reasonable regulations for Dover Amendment uses. Thank you.
Bylaw Committee report, Mr. Crook.
Stephen Crook, Bylaw Committee Chair. On our meeting on November 7th, we voted 3-0-0 to recommend the content of this article.
And a CPDC report.
Thank you, Mr. Moderator. On September 23rd, 2013, CPDC convened to hold a public hearing on proposed Article 14 to amend Section 4.2.2, Table of Uses, Section 6.1.1, the Table of Off-Street Parking Unloading Requirements, and Section 5.1.2, Table of Dimensional Controls, to establish reasonable regulations for exempt uses under Massachusetts General Law, Chapter 40A, Section 3, Dover Amendment. All documents were made available on the town website and at Town Hall. Public hearing was held to provide an opportunity for comment and to determine whether the provisions of the proposed Article 14 shall be adopted by the town. September 23rd, 2013, public hearing was opened at approximately 8 p.m. Presentation was made by the town planner. The hearing was opened to the public for comment and no comments were received. Public hearing was closed that same evening. CPDC voted 5-0-0 to recommend the proposed zoning amendment to town meeting.
Is there further discussion? Yes, Mr. D'Addario.
Thank you, Mr. Moderator. Ron D'Addario, Precinct 6. I'd like to offer one amendment if I could. Jean, would you be good enough to put that chart on for parking, off-street parking? And where it says church to the right of that, I'd like to just take that out and put none, N-O-N-E. So I'd like to make an amendment, Mr. Moderator.
Okay, let me just figure out where we are. Under church. This is part of the initial, this is part of the current bylaw, correct? This is not one of the changes?
No, this is new.
This is one of,
These would be the new inserted language.
okay, then I've got the wrong spot. Could you tell me again? I'm sorry.
I just, to the right where church is, it says one space for each 300 square feet. I would like to take that out and just put none, N-O-N-E.
Oh, no, okay, I'm sorry. Okay, is there a second to that? Okay, go, Mr. D'Addario.
Okay, the reason I say that is 300 square feet for each parking space. Basically, every church in Reading would be non-compliance. I'm a St. Agnes parishioner, and we would be about halfway there. I know the Episcopal Church has no parking. The Congregational Church has no parking. The Baptist Church probably would not have enough parking. So my feeling is not to put in a requirement that puts everybody in non-compliance. Now, if they're in non-compliance, it really doesn't hurt anything until they might need to go to the zoning board to get some kind of, maybe they're going to build something that might also be non-compliance or something like that. When they do that, then this could become an issue. So my feeling is the churches are already kind of struggling enough, and there's really no need to add another burden, even though they could probably go to zoning and get some kind of an exemption from it. But my feeling is, why put them through the ringer? Now, okay, there's a possibility that new churches may be coming into Reading. That's a possibility. I'm told there might be one coming on Main Street, North Main Street, a little north of the Old South Church, somewhere on the left is a possibility. But they cannot park on Main Street. So just by their situation, they would have to provide parking for their parishioners. I mean, other than that, I suppose there's a possibility of where Reading might suddenly get a flood of storefront churches. I just don't know if that's anywhere near likely to happen. I don't know, maybe a few churches on Main Street of the storefront type, maybe it wouldn't hurt. Maybe you'd put some life, a little bit of life in town. I don't know. But anyway, that's basically it. And thank you for your time.
Further discussion? Yes.
Richard Moore, Precinct 2. I have a question. How do you figure out principal uses? Because I know a number of the schools also have, excuse me, a number of the churches also have classes taking place at their locations. Is it by time? And then another quick comment.
I'm sorry, I didn't get the question.
How do you determine principal use?
Principal use?
Like, for example, a number of the churches have classes going on at their location. Is it by length of time that they are being used for teaching or for kindergarten or for daycare, or how do you figure out principal, what's the procedure?
Well, I think it would depend. With most of the churches, the principal use is the church.
And you know that why?
Well, because that's, off the top of my head, the churches in town, they're mostly, the site is mostly the church, the operation is mostly the church.
Well, the length of time that the parking is being used or the buildings are being used may very well be more time spent as a school.
Right.
Or
When I'll give you an example. We just had a site plan review, limited site plan review for St. Agnes.
yeah.
They came in, they had a rectory building, they had a building that was a school and then wasn't a school. We just counted it all up as the church property and regulated it, accordingly. So I don't think there would be, in the case like this, if somebody were coming in, this only applies going forward. So existing churches that are there are grandfathered in. This is for if a church wants to put an addition on or something's new is going on at the site.
Okay, and that's exactly where we want to talk to. I mean, what you're saying makes common sense, but if we don't put something in here that describes how you figure out principal use, I could see this being a bone of contention going forward. And the second quick question I have is school. It says 1 space per 7 students for elementary and then 1 space per each 3 students. Was the reason for the wording to be different?
Yes, we looked at a number of other communities, and the trend was to break them apart because of the differences between the 2 types of schools.
No, I meant, is there a reason why it says per 7 students as opposed to per each 7 students? Or per 3 students as opposed to each 3 students?
Are you asking about how we got to those numbers?
No, the wording.
The wording, oh.
The word each. Why is there?
What it means is 1 space for every 7 students.
Why isn't the wording consistent?
I don't know, I think we basically modeled this after another community. I'm pretty sure it was the town of Danvers. I don't know.
Is that worth fixing? Could I propose an amendment just to take out the word each in the second part just to avoid future confusion? And under high schools, it now says 1 space per each employee plus 1 space per each 3 students. Just take out the word each. So both paragraphs are consistent in wording.
Are you offering an amendment?
Yes, sir, I am. Sorry.
I'm sorry.
The amendment is to remove the word each from the phrase high schools, 1 space per each employee plus 1 space per each 3 students. That's second each before 3. Remove. Just to clean it up. Thank you.
Okay, so your amendment is to remove the word each in both places or all? I'm sorry, I'm very hard to hear that microphone.
Just before the 3. Per each 3 students turns into per
each 3 students, okay. All right.
Are
Is
we
there
okay? Susie? Thank you.
Town council?
Mr. Moderator, members of town meeting, I just wanted to follow up on a statement that Gene Delios provided in response to the earlier question by, I think, Mr. D'Addario. The provisions of Mass General laws specifically provide under Chapter 48, Section 6, that the zoning bylaw is prospective in nature. Any existing church or school that does not meet this table of dimensional or parking requirements is considered non-conforming or grandfathered. So as Gene mentioned, this would only apply in the event an existing church or school were to add on. Say you had an existing church that wanted to build a school, then the question is these dimensional and parking requirements for the new school would be applied to that proposed use. The zoning bylaw, technically, once it's approved by town meeting, it goes to the Attorney General for their review and approval to make sure that it's not inconsistent with state law. Upon that approval, it's considered to be effective as of the date of adoption. So that approval is retroactive to tonight if this bylaw is adopted. And just briefly, one further point, I think the question that was raised by the previous speaker regarding a school and a church, the example I've just given you is an existing church building a school. I think we could take the position that that school would have to comply with the parking requirements. And because these uses are technically exempt as to the use, a school or a church of this type can go into any zone in the town. And we've seen them actually located in the middle of residential zones, where there's a residential lot purchased, house is taken down, and a proposed church goes in. There's nothing to restrict a church going in the middle of a residential zone. However, these provisions would require that such a church would have to meet dimensional requirements, side yard setback, front, rear yard setback, and off-street parking requirements, so as to ensure that that use is going to be complementary to the neighborhood.
First of all, we don't have a second yet on the amendment. Second, okay. Further discussion? Yes, on the far right.
David O'Sullivan, Precinct 2. Gene, you said that the school things were kind of pulled from some other local area ones. Just as an example, did you do any analysis on how close our schools meet this kind of parking requirement?
We did a fairly rigorous analysis of kind of what we've looked at over the years, and we think this is very comparable to the way things have been regulated. I can tell you with regard to the churches, that's the standard that we've been using for a fact, and we just used it with St. Agnes.
It seems on the surface that one space per 7 students for an elementary or kindergarten seems kind of high to me, just knowing, and I haven't done a lot of work on parking regulations, but I was just wondering how close, say, some of our elementary schools fit this
Yeah, we
for
looked at
parking.
we looked at whatever we had. We didn't have much because most of it is public, but whatever schools we've had and we had any records on, we did take a look at.
How does the public schools fit in with this? I know they're not required to, but
Yeah, we didn't really go there since they're exempt.
I just thought that would be a good gauge to say, we know that our public schools, we know which ones have parking problems, which ones don't. Would have been a good analysis to say, and use that as a basis for coming up with this, instead of just kind of grabbing ones from different towns and not knowing whether they really work. That's all.
Further discussion? Yes.
Thank you, Mr. Moderator. Megan Young, Precinct 4. Jean, if I'm not mistaken, in the Dover Amendment, one of the situations that came up was a ballet school. How would they fit in this chart?
That's one of the reasons why we wanted to advance this, because there was a lot of discussion and concern by the applicant at the ballet studio, because that was exactly the scenario. They came in for a school, and we put them through a limited site plan review, and we did not have standards. So in this case, this is exactly the standard that we applied, 1 for 300. The ballet studio could not meet that standard. They needed to go to the zoning board to get relief, and the zoning board said to the ballet studio, give us something. We know you can never meet this, and we're fine with that, but provide something. And the site was very constrained, as hopefully most people are aware of it. It was a church that had no parking at all. And the town was very excited that this school was coming in and was wanting to work with them. And so they said, well, we can't provide any parking. And the zoning board said, well, you're gonna have to do something. So they came back with a plan, and they showed a plan with 2 parking spaces. Crushed stone, they carved out a little area, and the zoning board said, that's fine, you made an effort, that's all we're looking for. So it's a level of reasonableness. This is a standard, it can't always be met.
That's great. And I guess my question was, we haven't identified in here, like where would a ballet school fit in nursery, kindergarten, elementary, middle school, or high school?
Well, I think we'd have to take a look at it. I think, I can't remember exactly what their composition was, but we'd be looking for an overriding trend.
I guess, my question is, should we put in like commercial school or something? I mean, because I don't think a ballet school would fall into any of these categories.
I don't remember if they were mostly younger. I thought that the Northeast Youth Ballet was a more sophisticated, it wasn't like a children's, more geared to children. I thought it was more older kids, but I could be wrong about that. I'm not
Okay,
exactly.
I guess I don't know if I'm making an amendment or not, but just that maybe we want to put something other than, or like, so if I came in and I was a ballet school, I wonder if we should say something about a commercial, something else, other than nursery, kindergarten, or something. I'm not sure what. So, thank you.
Further discussion? Yes, Mr. Mom?
Jamie Maughan, Precinct 4. Thank you, Mr. Moderator. First, I'd like to speak in favor of the amendment to put none in the place of church. I know we did an expansion in our church a few years ago, and as Jean pointed out, we met basically that number of parking spaces, and by putting in that number of parking spaces, we had to have a very strange configuration. We alienated the neighbors by putting the parking up too close to the lot line, and with this amendment, we, along with most, if not all, the other churches in town, would be precluded from any other expansion. So if we pass this, we're saying our churches are static. So I'm in favor of the amendment. And then I also have some questions, and maybe it's just me, but table 5.1.2. I think I figured it out, but it took me quite a while. The setback requirements, minimum. The change is to change from feet to yards. So on first read, this would mean the setback is 20 yards, not 20 feet. After studying it and looking at it for about half an hour, I finally figured out, I think, that we don't mean 20 yards, yards as in 3 feet, we mean yards as in the lawn. If anyone else is confused about, I won't propose an amendment to change that wording from setback from yard to lot line, but if anybody else is confused, or if anybody thinks this could be interpreted to mean the setback is 60 feet, 20 yards, 60 feet, please, if I'm the only one confused, then forget it. But if anybody else is, or anybody else thinks it would be clear, please, please speak up. Or Jean, can you confirm? Was I right in my original interpretation? Does that mean the setback is 20 yards, 60 feet?
Ms.
If
Delios?
I could, Ms. Murray. At the top of that chart, you'll see that there's a note, it says in feet unless otherwise noted.
Right.
So when we say yard, we're referring to the yard that being a side yard, a front yard, a rear yard.
It just took me quite a
In
while to figure that out.
Yeah, the zoning term for the yard is meant to be a yard that is the front yard, a yard that is the rear yard, and a yard that is the side yard.
But we mean 20 feet from the lot line on the side.
That's right. And at the very top, where the label is Table of Dimensional Controls, we make a note to try and clarify in feet unless otherwise noted. So the yard is just the title. Sorry.
Further discussion? Ms. O'Neill?
Mary Ellen O'Neill, Precinct 4. 2 questions. One is, it does say in the description that that Dover Amendment stipulates that certain uses, including nonprofit, educational, and religious, cannot be prohibited. But I see that we only are addressing here school and church and not nonprofits. Kind of ties into my question that Megan raised about the Northeast Ballet School. One, I would assume that commercial schools would not qualify under this. Commercial is for-profit, so I wouldn't think that any for-profit school would qualify.
That's correct.
Okay. What is the Northeast Ballet? Is that nonprofit?
Nonprofit.
So it really wouldn't we don't have a category here, thank you, for nonprofit.
That, by definition, they're all nonprofit. That's.
But I think there's a third thing called nonprofit, separate from schools and churches, right? Nonprofit,
No, to be able
like
to
a health
qualify
or...
under this law, you have to demonstrate that you are a nonprofit. We look for articles of incorporation and other tax documents to verify.
Right, so I'm saying something like the Northeast Ballet School, we would qualify that as a nonprofit as opposed to either an educational school or a church.
They all have to be nonprofits. Yeah.
The town council would like to weigh in.
Mr. Moderator, I think you're describing three categories. The statute provides zoning protection to two of the nonprofit categories we're talking about. Nonprofit religious or educational institutions. If you have a nonprofit such as the United Way that decides to go into a particular location, that particular nonprofit would actually have to meet zoning requirements. If they were placing office space in a residential zone, if it's not allowed, they couldn't move there. But the statute under the Dover Amendment, which was originally enacted in 1951, specifically says, under Chapter 48, Section 3, these protections are as to nonprofit religious and educational uses.
Okay, so that's a little confusing, the description, the background. I thought there were three separate categories. Thank you.
These protections and these dimensional regulations would apply to those two that I've described.
So there are only two.
Education. Right.
So it only protects two categories.
That's correct.
Nonprofit schools and nonprofit churches.
That's correct.
Okay.
Mr. Ensminger?
Thank you, Mr. Moderator. Dan Ensminger, Precinct 7, and I rise to speak as a town meeting member on this article. I cannot support this article as originally drafted. I am favorable toward Mr. D'Addario's amendment, and I'd like to offer a further amendment. If I might, this would be on table 512, table of dimensional controls.
We generally take two, but go ahead and we'll see if it...
Okay, on the last section of that table, the title, exempt uses, school and church, strike the words and church.
In church, okay. All right, is there a second? Second. Mr. Ensminger?
I think we've heard a number of previous speakers address the fact that most, if not all, houses of worship in this community will become non-conforming in one respect or another, either by virtue of not having enough parking currently to expand or being constrained by these front and rear setbacks and minimum area of square feet. I think it's wise to delete the churches from this for now. Perhaps we can revisit this under the general review of zoning that's going on, but this strikes me as being potentially punitive to any house of worship that wants to expand beyond its current square footage. I would hate to see people having to go to the Zoning Board of Appeals for every single case. Perhaps you have to pay for legal counsel to do so. It just strikes me that this is a solution to a problem that does not exist in Reading right now. These churches have coexisted here with their current parking, many in their current footprint, and some are considering expanding. I know St. Agnes is considering selling their lower building, again, for another use. The town did sort of walk away from that deal. We all understand why, but that particular sale could be affected, just hypothetically, by this, depending on the use to which that building is put. So, for any number of reasons, I would offer that amendment, and I certainly do support Mr. D'Addario's.
Ms. Herrick?
Thank you, Mr. Moderator. Karen Herrick, Precinct 8. I understand the intent of this to clarify things and make zoning and permission for certain businesses and schools easier. I have a concern because I think I heard that we really haven't spoken with the school department, so we don't know if our existing schools meet this. I have a hard time voting for zoning where we don't know with generally accepted recommendations on parking sort of goes along with what we have, and I can tell you that from the day it opened, the Wood End school parking has been insufficient, and part of that, I believe, is due to the Aquifer District restrictions on that particular school. And there's a working group in progress right now, and every single one of our, every time we put up a list of viable options for solving our school space issues, it's, we need an addition on every elementary school. And who's to know whether that's gonna be the way we go? But I think the school department needs to weigh in and say whether this is gonna be reasonable, because if we end up doing 1 addition or 5 additions or 3 additions or a new school building, they're gonna have to go through this. I'm not gonna be able to vote for this the way it is for that reason.
Would you like to use the microphone, please?
Reading Public Schools are not affected by this. They are exempt from zoning entirely. This does not impact them. They could have no parking.
I thought, excuse me, I think, so I heard a couple times tonight that if a school or a church wants to put an addition, they have to abide by this. Did I miss here?
Mr. Brackett?
Mr. Moderator, the provisions of the Mass General Law, Chapter 48, which governs zoning, allow cities and towns to exempt municipal functions, municipal buildings from zoning. Reading, through the CPDC and town meeting, has acted to exempt all of the town of Reading municipal operations, including the school department, from zoning. So if a school department building was proposed for an addition, that addition would not need to meet this parking table.
Okay, thank you for the clarification.
Further discussion? Ms. Delios?
Thank you, Mr. Moderator. I did want to share some of the data that we did look at. We looked at the Goddard School, we looked at Austin Prep, and we looked at 5 census. And in every case, the proposed parking that was approved is pretty much in line with exactly what we're calling out tonight. The standard of 1 for 300 was applied to the Goddard School. The 1 for 300 was applied for the Austin Prep, and the 1 for 300 was applied to the 5 census. So we have used this standard consistently in those 3 cases. So it's already being used. What's before you tonight is to codify that. Thank you.
Mr. Daddario?
Thank you, Mr. Moderator. Ron Daddario, Precinct 6. Mrs. Delios used the comment that in regards to the churches, that the present churches would be grandfathered in. And my question here, and I don't claim to have complete knowledge, but maybe even for town council who mentioned this, and that is when you're deemed non-conforming, then it's not exactly grandfathered in, gives the impression that you got a free pass. And I think the way it is you have a free pass as long as you don't make a change to your building that, again, would be a non-conforming change. And then at that point, I'm wondering, could parking then be a consideration? And that would then be, I think, in my opinion, somewhat punitive.
Ms.
Sure, I
Delios.
can answer that, thank you. So the only way that the churches or any other of the uses would be getting into this is if they fall within site plan review thresholds. So it's 500 square feet of exterior alteration or 2,000 square feet of interior. So I'll go back again to the case of St. Agnes. St. Agnes came before the CPDC for a limited site plan review, and they did not have the 1 for 300 parking standard that we've been using, and that's before you tonight. They were going to do mostly an interior alteration, put in a handicap ramp, some other things. The CPDC looked at that knowing that they did not have the parking and decided that they were pre-existing non-conforming with regard to parking, and they were approved.
Okay, now with that stated, what it means is that it did come back, and it had to be examined again. In this particular time, they got a pass, they were approved. But next time, I mean, it's a question. So my feeling is, why cause them agita, you know? Why cause them stress? What I think Mr. Ensminger said it properly, is that we've got these rules that are not necessary. There are not a huge influx of people wanting to build churches in Reading. So I would say, that's why I would say, if you would support that amendment, at least none for the churches, and spare them any extra stress. Thank you.
Further discussion? Yes. Ms. Sansalone?
Yes, I am. Thank you, Mr. Moderator. I have a comment. I think that this article it has some sloppiness in it, which has generated some of the questions, and I think I could use some cleanup in that sense. I'm not going to offer a 17th Amendment, but I'm a little bit surprised that this flurry of protection for churches. Aren't we a religious lot? But I thought that the point of zoning was to set community standards where you generally agree on what you want your community to look like and live like and be like. And here we are codifying some standards. We're grandfathering in everyone who's there already. And yet we're trying to make exceptions before the fact. I think it's foolish. I do think that it could use some housekeeping attention, the actual article, but I think that all of this concern about what if in the future ABC Church comes before zoning and asks for something it's alarmist, and I think that it's premature. I would vote to I would not vote for any of the amendments that have been proposed. Thank you.
Further discussion? Yes. Mr. Barnes?
Thank you, Mr. Moderator. Jonathan Barnes, Precinct 5. Just a question, if I can, Jean. And I'm speaking now about the application of this proposed zoning bylaw to the churches. And I should say at the outset, I am a strong adherent to religious freedom and religious belief and religious observation. And I encourage that as much as anyone does. My question is, in the section of the background, I know the standard that you're seeking to apply, and you say on page 24 that, and you've said tonight, that the standard that you're applying with respect to the churches is the formula currently being used by the building inspector in several churches in Reading. Are there any churches in Reading that under this particular standard would meet this requirement as it exists today? I know they're not subject to it because they're grandfathered, but are there any, do you know, or does anybody know, that would meet this currently?
We didn't do that analysis. Again, what we brought forward tonight for town meeting to consider is what has already been past practice and interpretation of how parking standards apply to religious institutions. If the article doesn't pass and an application comes in for a church tomorrow, the building inspector will use the 1 for 300 standard. It's just it isn't communicated clearly to the applicant in the zoning.
Okay, thank you, and I agree. I was asking because I'm curious to know, I mean, I understand that the standard is one space for each 300 square feet of gross floor area. I'm not totally sure how that translates to an existing site, how many vehicles that is, with respect to an existing church, so I can get a sense, or town meeting members can get a sense as to what that would look like at an actual church gathering. But I understand that we may not have it.
I'm sorry, there is one, St. Athanasius, meets the requirement.
Okay, thank you. I did, if I may, do just one other comment. I also am opposed to Mr. Daddario's amendment. I believe, as I said, I believe strongly in religious observation, but I also believe strongly in the right and the obligation of the citizenry to enact appropriate regulations. I think that applies to the zoning regulations, and I see the zoning regulations exactly in the manner in which town council characterized them. They are largely intended for the community to be, as he defined it, zoning protection. And that is land use should be in the interest of the community with respect to use requirements, setback requirements, parking requirements, et cetera, that are in the best interest of the town. I was trying to get a sense as to what this standard is so I can get a better understanding of how firmly I believe that this is a reasonable standard. I do think it is generally intellectually. And hearing that one church does comply with it, I think I do have a better sense, and I would simply say that with all due respect to religious observation in churches, the land use protection and the zoning protections, in my mind, would apply equally whether the use is for dental work or residential living or residential work, or for God's work. And one situation should not be any different than the other in terms of the purpose and intent of zoning protection. So I'm opposed to the amendment to allow for the unfettered right to have zoning standards different from everything else. Thank you.
Mr. Brown?
Thank you, Mr. Moderator. Bill Brown, Precinct 8. On the setback requirements, 5.1.2, previous speaker spoke a little confusion as the word yard instead of feet. Perhaps we should just flip those and say front yard, side yard, rear yard. And I think that would solve a lot of problems, because as I watch CPDC and all the other meetings, they always refer to it as front yard setbacks, et cetera. So I'd like to offer that as an amendment. Just flip the two words in all three cases, if that's acceptable, sir.
Okay, I will accept it because it is completely separate from all of the others. We've got to be careful we don't get too confused on this. So your amendment right now is to reverse the words front, side, and rear.
Because again, Mr. Moderator, when I watch most of the meetings or attend them once in a while, they generally refer to side setbacks and everything else. I think it's a general practice, and in the overall, I don't think it makes a heck of a lot of difference, but brings some consistency. Thank you.
Okay, is there a second? Second, okay. Further discussion? Yeah, what, Ms. Binder? Was somebody had a point of order, or? Yeah, okay. There's a lot of people waiting. Ms. Binder?
Thank you, Angela Binder, Precinct 5. Under school, I have a question, nursery, kindergarten, elementary, middle school. Would home daycare apply here too?
Yes.
Okay, I think that might be very strict for a home daycare who is in a neighborhood, a Cape with maybe a single parking space, who works, maybe has one employee, and 10 kids would not work into that. So I think that would be difficult for home daycare. I have a question about the fairness of public schools being exempt and yet private schools not being exempt, and say Austin Prep having to meet parking requirements that Reading High School doesn't have to meet. And there was just a proposal, it didn't go through for numerous reasons, but for the public, for the town, the public school system, to buy the lower school building from St. Agnes and to put the kindergarten space in there. And I know there was an outcry because of parking and drop-off and its proximity to the middle school. But my question is this: we're talking about land use, zoning protections, how it should reflect values. Now, had the town, had that project gone through for the town, that school would have been exempt from these regulations. Is that true? That they would have been exempt because it's a public school?
As town council indicated, the town is exempt.
Okay.
But I will tell you, because I was involved in that, town staff looked very carefully, particularly with the police department, on safety issues and traffic circulation, and had very real concerns. So even though we are exempt, we evaluate projects to make sure they're going to work. You know, when we're asked, we give our opinion.
Right, and that's one of the reasons why it didn't go through. But my point is that there could be, and this could be the case because the town wanted to buy an old school building from a church. There could be a project that, the exact same project, that if it's built, if the school is built by the town, would be okay. But if that same exact project were to be done by a church or a private school, that wouldn't. So it seems like, you know, there's a penalty for being a school, for being a private school, that, you know, doesn't seem fair. Doesn't seem fair that if it's the same project, it's the same project. Or if it's a similar project, it doesn't seem fair. The town is probably going to have to put an addition on to some school building, and that won't be fair. But if Austin Prep, and they would be exempt, but if Austin Prep wanted to put an addition on, they would be subject to this. So I don't like that. If it's, you know, I don't like that exemption. I don't know that, you know, people don't want special exemptions for churches because they're churches, but I also don't think that they should be penalized. If a church is running a school, then it's a school. And so for those reasons, I'm against this. Thank you.
Further discussion? Yes.
Thank you, Mr. Moderator. Charles Stanley Moran, Precinct 7. I can understand people's concern, those people who belong to churches in Reading, about this regulation impacting their particular church and other churches. And I think the comment was made, you know, there isn't any great influx of churches coming into Reading, but I think people need to maybe think about the extremely large church that was built along Route 2 in Belmont a number of years ago. And, you know, people in Belmont, I think there was a lawsuit involved and all. And, you know, churches do, you know, migrate to suburbs, and they could buy up some lots and put it next to some single-family houses. And I don't think those people would really like, you know, a big monstrous church with hundreds of cars coming in on the weekends. There also was a church, I believe, along Route 9 in Brookline or Chestnut Hill. I'm not sure exactly which community it was, but I know that there was, you know, a lot of opposition from the homeowners in that area. So, you know, yes, we haven't had a new church in a number of years, but every once in a while they come along, and once a church, you know, buys the property, you can't then come in and put in regulations after the fact and, you know, prohibit them, because, you know, then you're discriminating against a particular church. So, you know, let's make the rules that establish what our standards are for the community that the other speaker had mentioned. So I'm opposed to the elimination of the restriction on parking for churches. Thank you.
Yes. He's been, do you have an immediate comment? Okay, all right.
I'm sorry, I just want to clarify the question about the daycare, home daycare. I was thinking you were meaning home daycare that was nonprofit, under the umbrella of what we're talking about. But I want to be clear to say, if it's not a nonprofit, if it's a for-profit home daycare, then it wouldn't be subject to these standards. So everything in my brain tonight is only considering those that would apply here as a nonprofit. So I just want to be clear about that, sorry.
Thank you, Mr. Moderator. Nick Safina, Precinct 3 and CPDC member. I'd like to touch on what I think are misstatements about the restrictions on these uses. One of the most powerful forces that these uses have is that they are exempt from the use restrictions. They can go anywhere. And so if a church wanted to expand, it could simply buy the adjacent residential parcel and expand into it. And those powers aren't granted to commercial uses that are restricted to certain zones. So if the expansion were large enough, they would need additional land, they would be buying land, and no one could stop them from going in there. And make no mistake that these uses act like commercial properties. They're traffic. Those cars don't miraculously appear and disappear. They have to drive through neighborhoods and find parking spaces. You know, the water doesn't miraculously dissipate from the site. It has to drain into the use, and they're exempt from all of that. The biggest power they have is they can go anywhere, they can configure any way they want, they can go deep into residential neighborhoods, and these restrictions are reasonable to protect those neighborhoods.
Mr. Greenfield?
David Greenfield, Precinct 5, speaking as a town meeting member. I haven't heard enough about the implications of the change on the citizens, on residents. I'm uncomfortable with what I'm voting on, and so in that regard, I'm leaning towards voting against this. I also haven't heard enough of why this has to take place now versus be deliberated. So I'm uncomfortable, and I think there's some language cleanup that might be needed as well. So I'm leaning against it for right now.
Further discussion. Mr. Crook?
Stephen Crook, Precinct 2. It's been observed that there does not seem to be a large rush for new churches to come into Reading. What is interesting to note, though, is those who may not know, Grace Chapel, who is a large church in Lexington, recently opened a new church in Wilmington at the site of the old Casa de Fior function hall. When they were looking for a place for a satellite initially, their target town was Reading, with the adjoining towns around it as also target areas. As it happened, they could not find a suitable place in Reading, so they ended up in Wilmington. But it is theoretically possible that another church could come in such as that. And as things stand now, there is no control. On the other side, I have also a letter from a constituent who's a member of the Baptist Church, a church which I also know I attended for about 20 years, ending in 2007. I no longer attend there. And she says, among other things, she says, while I understand the need to provide parking controls for public safety, the concern I have is the impact on imposing parking rules to the existing church structures that are property bound by their location in the downtown area. And then she continues, for most of the existing landlocked downtown churches, compliance will be impossible. You may not know that we at First Baptist Church share our parking with businesses around us and help to accommodate them in midweek use, and they reciprocate by sharing their lots on us on Sundays. And she then continues, to consider the unintended consequences of the zoning change and carefully consider the impact of Reading's quality of life in the face of loss of downtown churches. That said, I understand at least if they were to do even a large internal renovation, they would not increase their nonconformity, so would not have to go to the ZBA for a special permit. Is that true?
Ms. Delios?
Thank you, Mr. Moderator. As I was saying, the example of St. Agnes, where they did do an interior renovation as well as put a handicap ramp in, they were given that status, and even though they are non-conforming, They were not increasing the nonconformity. So they did not have to go back to the Zoning Board of Appeals. They went through a limited site plan review, and the CPDC approved their site plan.
On the other hand, if they were to build an addition onto the outside, it probably would trigger the need to go to ZBA for a special permit.
That would be something that would be increasing the nonconformity. So that's what triggers ZBA.
Now, do I also recall that there's a special exemption for handicap ramps, or is that just for
That's
residential
correct.
uses? Thank you.
Further discussion, Mr. Brackett?
Mr. Moderator, just briefly, there was one of the previous speakers raised a question as to the need for this particular type of zoning control at the present time. And one of the issues that arose during the review of the St. Agnes project, where the school department was considering acquiring the building there, was trying to determine what the dimensional regulations would be for St. Agnes Church after the property was subdivided. And if the town were to then acquire the property with the school on it, then the church would be left with a certain portion of land. And then the next question was, well, how does that affect the parking requirements for the church? Will the church be rendered more non-conforming? At that time, we reviewed the zoning bylaw and the table of dimensional regulations, table of parking regulations. We realized that we did not have a specific category of dimensional controls or parking controls for the church or for schools. A question that could be presented, and I only mention this not to be alarmist, but just to suggest to you that if a proposed church were to come into Reading and acquire a piece of property and to seek to build a church with a small or large congregation, up to the present time, what the town's been doing, the building inspector has been using by analogy other dimensional and parking requirements, because we don't currently have a specific table of parking requirements. And as I mentioned, the Dover Amendment was essentially enacted in 1951 after a decision by the state's highest court. And there's a 1966 decision by the state's highest court involving Radcliffe College challenging Cambridge over a parking requirement for the library. And the state's highest court determined that the parking regulation in 1966, as applied to the library, was a valid exercise of zoning power. But if we had a proposed church, we don't have a schedule of dimensional parking regulations, then if an applicant was unsatisfied with the building inspector's determination, the applicant would appeal to the ZBA. And if the ZBA affirmed the building inspector, the applicant could appeal to the land court. And I can simply suggest to you that one of the first questions a judge of the land court would ask would be, Mr. Brackett, can you tell me the source of authority for the town of Reading to impose this parking requirement and this dimensional requirement on this church? And the problem I would have, frankly, under that scenario, would be that we don't have a specific table of dimensional parking requirements for churches or schools. We're arguing by analogy. I think we could still make an argument that the church should be subject to required or at least appropriate dimensional parking regulations. But I would simply suggest, and I just ask for your consideration, that one thing the judge would ask would be that since the zoning amendment under the Dover decision has been changed, and it's been in existence for more than 50 years, that the absence of a dimensional regulation or a parking regulation for an exempt use would appear to be a possible weakness within the current zoning bylaw. So that's the reason, in working with Gene Delios and the town manager, we were suggesting that this type of zoning regulation would be appropriate to put forth at this time. Thanks.
Further discussion? Mr. O'Neill?
John O'Neill, Precinct 4. Despite what I think is the sense of the group, I'm going to speak anyway. I'm a parishioner of St. Agnes, but I've attended St. Athanasius often over the years. And I want to say that, to me, what was very illuminating was the 1 to 300. Because if anybody's been to St. Athanasius, parking's terrible. And so the standard is a very, mild, very mild, as far as what we were talking about. And from my understanding from the conversation, it's what's being used anyway. So if you don't pass something, you're going to have the same standard, but it's going to be undermined because it's not codified. And so, in fact, it does tie, legal counsel's, one hand behind his back when he's trying to uphold what the town has said is what the standards that they have used and want to continue to use.
Further discussion? Yes. Ms. Phillips.
Thank you, Mr. Moderator. Linda Phillips, Precinct 7. Despite the fact that we're using an old standard for churches, I still would be uncomfortable with making churches to give them any difficulty if they wanted to add any addition on their facility, which would trigger all this conversation and zoning board and everything else. Because number one, I feel like we need all the spiritual life in town we could have. Every town needs a little more. And number two, I was involved in the school projects of the Wood End School and the addition at the Barrows School. And I know at the time it was a great concern that if we were spending a lot of money to upgrade those schools and build a new school that we now know we didn't need, that there was supposed to be parking on site. And it was supposed to cover for the teachers, for the parents who visited, for school activities, for parent night, and that kind of thing. And the schools are technically exempt, but Reading said, we still want to go through CPDC and the zoning board, which I attended those meetings, because we wanted to have a sense of fairness. That's been used before tonight, a sense of fairness, that we were not just plopping these schools in residential areas that were putting the neighbors at risk for hazard or putting the students and teachers at risk for any emergency the site might require. And Wood End is on a dead end. That is also one of the requirements that the school building assistants said was a prerequisite not to build a school. So school building authority had regulations and guidelines for parking on site, so not to interfere with the neighbors in a sense of fairness and in the interest of the community to be a good neighbor. And we allowed those schools to not be in the interest of the community. We forced those neighbors to accept more cars and more on-street parking, because in the Barrows School, we made the site smaller because we added to the Barrows. So but that wasn't a problem because it was a school. Everybody was told to just be quiet, and we should be happy that we're having these new facilities. But it still put a lot of constraint. At the time, I represented Precinct 6, which was in the Barrows area. Lot of concern about the traffic. And now we're trying to do the same thing to the churches. And I'm saying it's not really fair. If we're going to be fair, the schools, the way the schools are now, and the parking in the high school, I know we lost 40 to 60 spaces here because of the new configuration on the site. The Wood End School, we were promised for 44.
Remember, we're talking about the article before us. I know you needed a little background, but please stay on the subject.
Well, I'm just saying that now we're trying to make it more difficult for the churches if they want to enlarge, that we're going to trigger these new zoning controls, which will make it more difficult for them. They'll have to hire attorneys and whatever to do that. But the schools didn't have to hire attorneys to go to the zoning board, and the zoning board gave them regulations, and they chose to ignore it, and that was okay. That's not fair for the schools to do what they want. And now if we're talking about adding on to any of the additional schools, they're not going to trigger any changes. And now the neighbors will still be forced to have more parking, more drop-offs, more busy times. I live on Willow Street. We have Austin Prep. There are certain times I don't leave my house because I can't get out onto Willow Street, but I've had to accept that. But at least they have on-site parking, and they don't park on the road, which makes it more dangerous for the cars to travel on that street. So I think fairness is important, and I don't think we should be hampering the churches, and I would support Mr. Ensminger's amendment. Thank you.
Further discussion? Yes, right on the edge.
Greg Savatelli, Precinct 6. Just to reiterate a couple of things I've heard, we've talked about fairness and talked about for the schools or the churches, but one of the things I heard mentioned earlier was about the neighbors. And while it's great that we want to try to get some fairness between schools and churches, I think if we look at the neighborhoods, allowing us to have a codification of restrictions on building additional nonconformity so that those neighborhoods don't have to have increased traffic, increased parking, increased inconvenience without appropriate regulations around that. I don't think that's such a bad thing. If the churches really want to expand beyond what they have and they're not to compliance and they really want to grow their areas, they can look at other locations or they can look at bringing up requests for those exemptions. But I think codifying that is actually something that's useful to protect our neighborhoods, just like we did the other night talking about billboards. We wanted to protect what we view our community as. So it's not just about protecting a church or protecting the schools, it's about also what our neighborhoods and what our community wants. So I think this is something where right now our CPDC is actually using the one space for 300 for across for these applicants coming in. I think having this language put into place is a good thing to start to bring us some restrictions or bring us some guidance around what should be produced. If we want to talk about things about our public schools and whether there should be more conformity to that, maybe that's a separate discussion, a separate amendment down the road. But I think in terms of what we're talking about today, we're talking about nonprofit schools outside the public forum and nonprofit churches that should look at these conventions for our community. Thank you.
Further discussion? Mr. Tuttle.
Thank you, Mr. Moderator. David Tuttle of Precinct 3 and a CPDC member. This is messy because we currently do not have, as Town Council mentioned, any regulations in the extant bylaw. So that in the worst case, the Church of the Third Moon of Jupiter could buy a residential property and build a 60-foot high church within a foot of the property line with zero parking. And it's unlikely. They're entitled to their own, worship of whatever. But it's unfair to the town, it's unfair to the neighbors. The purpose of zoning is to have some constraint. Whether or not these are the right numbers, they're reasonable, which is what's required for the state law. And we need to have the dimensional control, we need to have something in the bylaw to fall back on. Thank you.
Ms. Delios?
I just want to echo what the previous speaker said about churches coming in. I don't think we've mentioned, maybe it was Mr. Daddario mentioned it. Right now we have an applicant for a piece of property. We don't know how serious it is, but they did come into the counter a couple of weeks ago. A site that was a 40B site up on, we call it 885 Main Street. For some of you that might have seen the paperwork on this, it was called Splendid Splinter, and I think it did go to the Board of Selectmen. What Splendid Splinter was going to be is a 40B. It was going to deconstruct an existing residential neighborhood. It was going to take 2 acres of land and put 20 housing units in. That's what's bad about 40Bs. They bypass local zoning. Now we're in a position where that same site is being seriously looked at by a church. I don't know the name of the church, but the applicant came in and said they want to put a church there, and they're looking to buy the site. That would deconstruct that residential neighborhood with no standards. That's why we're here to talk about zoning. Thank you.
Further discussion? Mr. Brown?
Thank you, Mr. Moderator. Bill Brown, Precinct 8. I think there's been a lot of discussion between public schools and private schools. I'd like to remind the body that under the law, we have to provide schools for our students. That's perhaps why we are exempting ourselves from zoning. We have to provide a place for a fire station. Perhaps that's why we exempt ourselves from zoning. We have to have a police station. We have to have public works, and the list goes on. So that's the reason why public entities are exempt from zoning, because if you didn't, nobody would want them in their backyard, but they'd want all the services.
Further discussion? On the aisle?
Thank you, Mr. Moderator. Karen Burke, Precinct 2. One question I would have is whether or not church property would be construed to include parish houses that are not within the site of the property. Some of the churches own facilities where the ministers live, and they're not on that site. Secondly, I'd just like to clarify if ZBA could then allow a church, give them a variance or a permit, if they came with a, say, an interior project, but did not meet the 1 space per 300 square feet, could they then allow that as a non-conforming use? And would that be more easily challenged in court by anybody who sought to challenge that? And lastly, it seems to me that most of what we are talking about is not the setback requirements or the lot size requirements, but the parking regulation. So I think that seems to be the issue that's causing most of the concern in terms of comments. Thank you.
Do we have an answer, Ms. Delios?
Thank you. So if I understand correctly, the church property with a parish house not on the site, we would be, under site plan review, we would be looking at the site where the work is being done. So if there were an ancillary parish house on another site, we would not be looking at that. We'd just be looking at the site that's being applied for some site plan review. So that's the first one. If a church were doing interior renovation and they didn't conform to the 1 for 300 square foot standard on parking, that's pretty much the same example as St. Agnes. They did an interior renovation, they did not meet that standard. They never had to go to ZBA. They went through site plan review, CPDC reviewed it and said that the test being, is it more non-conforming? And that test was met. They were not more non-conforming. They were protected. They were not increasing the nonconformity of the site. So they got approved under site plan review. We looked at all the other aspects of site plan review that we consider, and they were all set. And the third thing is about the parking. You can vote it up or down tonight. When we go back to work on Monday, if someone comes in, we're going to use the 1 for 300 parking standard. That's all we have to go by, and as has been said, it just puts the town in a more difficult position because it's our best guess. Thank you.
Further discussion, Mr. Crook?
Stephen Crook, Precinct 2. Mr. Moderator, would you accept a motion to move all the amendments?
Yes, I would. Move the question, you mean? Yes.
I'd like to move the question of all the amendments.
But leave the main motion open?
Leave the main motion open.
Okay, is there a second to that motion? Okay, we will need counters. Mr. Brown, would you do the honors for your side plus the Finance Committee? Mr. Crook, while you're standing up, you can do your side. Mr. Rushworth, would you take the other half of the center? And Ms. Russell, would you take your side plus the Board of Selectmen? Now, the question before us is to end debate on the 4 amendments only. Everybody understand that? All right, all those in favor of ending debate for the 4 amendments, please rise. 30?
22.
22?
28.
28?
36.
36. And those opposed? One? One?
3.
3?
4.
4. The vote being 116 in the affirmative, 9 in the negative, the question has been moved, and we will proceed to the 4 amendments. Let's take this carefully. We take them in reverse order of when they were made, so the first amendment we will be voting on will be Mr. Brown's amendment, which would reverse the words front yard, side yard, and side yard again. Rear yard, I'm sorry. Front, yeah, you're right, I'm sorry, excuse me. All right, all those in favor of that amendment, please raise your hand. Those opposed? And that motion carries. All right. The next one is the one made by Mr. Ensminger, which on the second page, exempt uses, schools and churches, and church, excuse me, it removes the word "and church." All those in favor of that amendment, please raise your hand. Those opposed? And that motion does not carry. Next is Mr. Moore's amendment, which would remove the word "each" after "per" and 3 students. All those in favor of that amendment, please raise your hand. And those opposed? And that motion carries. And the final one, Mr. Dario would replace the section on church with the word "none." All those in favor of that motion, please raise your hand. I'm sorry, that is what I meant. Yes, good point. Okay, does everybody understand that? Okay, all those in favor of that amendment, please raise your hand. Those opposed? And the motion does not carry. All right, debate is now open again on the main motion. Yes?
Thomas Day Ryan, Precinct 1. I move the question.
All right, is there a second? Second, okay, the question has been moved on the main motion. Again, I would ask those same counters to please help out. Those in favor of ending debate on the main motion, please rise. $28.
25.
25.
29.
29.
19.
19. And those opposed?
Five.
5.
3.
3.
6.
6. 5. 19. 19. The vote being 101 in the affirmative and 19 opposed, the motion carries. Business under Article 15. Oh, I'm sorry. I'm sorry. Getting ahead of ourselves here. All right. We're now voting on the main motion. This is also a 2/3 vote, so once again, we will need the counters. All those in favor of the main motion, please rise. As amended, by the way. $24.
21.
21.
25.
25. 32. And those opposed? Six.
7.
7. 5?
5.
5. The vote being 102 in the affirmative and 23 in the negative, the motion carries. We will now move on to Article 15. Before we take that up, I just want to point out, excuse me 1 second. Before we take up 15, I just want to point out the issue before the body is not should we have these clinics or where they should be, but whether or not we should enact a temporary moratorium. So please keep debate on that subject. Mr. Safina?
Thank you, Mr. Moderator. Move that the town vote to add a new section 4.13, temporary moratorium on medical marijuana treatment centers / registered marijuana dispensaries, and amend section 2.0 definitions to include medical marijuana treatment centers / registered marijuana dispensaries of the town of Reading zoning bylaws as follows.
Mr. Bonazzoli moves that we dispense with the further reading. Is there any objection? None appearing. Is there a second? Second? Ms. Delios.
Thank you, Mr. Moderator. Just for a little background on the topic of medical marijuana treatment centers. Question 3 passed on November 6th, 2012, allowing medical marijuana treatment centers. Town meeting approved back a year ago at a subsequent town meeting in 2012 prohibiting this use. In early 2013, we received word with our fellow communities, Wakefield among them, that the Attorney General was disapproving the prohibition of this use. And at the same time, there was an Attorney General approval of a moratorium, a temporary moratorium on these uses for the town of Burlington. So in the spring of 2013, a moratorium was identified as the suggested next step. It's a long definition of what we're talking about here. But just to make the point that these are facilities that not only dispense medical marijuana, but there's also a provision under this law that says they can grow, cultivate, manufacture, make various products like lozenges and various things with the medical marijuana. So it's quite a complicated undertaking to even understand what we're talking about. So why do we want to do a temporary moratorium? As hopefully everyone in this room knows, the exciting news about the comprehensive update of the zoning bylaw. I can see everybody's really excited as I am with that idea. It's going to be very exciting to think about how we're going to bring it back here next year. But having said that, the comprehensive update of the bylaw is really a big opportunity for the town to delve into complex and difficult issues like medical marijuana, and to think about and to plan for all of the many elements that have to be seriously thought about for how we're going to accommodate this requirement now. We can't prohibit it. So what this does, if there's an affirmative vote tonight, is it allows the time to really look at how we're going to go about regulating medical marijuana treatment centers or registered marijuana dispensaries. I won't bore you to tears about the purpose of zoning, but I think from the spirited debate that we had tonight, we can all embrace the fact that we're trying to preserve the town of Reading, and we're trying to minimize conflicts and maintain the character. I, for one, am a big advocate of taking the time that you need to study things like this. So How we do this is basically we've inserted a definition. That's in 2.2.2.1.2. Then we've had to renumber, so I hope that isn't confusing, but unfortunately our definitions are alphabetical, so we had to do some rearranging there. And then we inserted language that basically says for the next year, the town will have a temporary moratorium on these uses. So some of the things that we'll look at during this moratorium period is where these uses should be allowed, how to allow these uses with minimal impact. Look at perhaps using a special permit process so there's a little more detailed review of when these proposals come in. We definitely want to work with our community partners, including our CASA, the schools, the police department, the health department, and many others. We also want to take a very good look at the state regulations, make sure we understand it. And with the help of our consultant and the Zoning Advisory Committee, we hope to get input from the public at these public forums. This zoning can really be worked on and make it work for Reading. If this article fails tonight, we're back in the position of not really knowing what that means. The by right or special permit, that's another idea for possibly allowing this. If the center wanted to go into a storefront and make minor changes, less than 2,000 square feet of interior alteration, less than 500 square feet of exterior alteration, they would essentially bypass site plan review and simply get a building permit from the building inspector. So it's hard to know how this would happen under the existing zoning. A yes vote for Article 15 would prevent a medical marijuana treatment center from locating in Reading until after the moratorium period is over. When the comprehensive update of the zoning bylaw will be before town meeting a year from now, that's when we can have something that's well-crafted and really is suited to Reading. Just want to say also that the under this provision of law for zoning, there's a clawback provision that says the date of the notice of the public hearing for CPDC is when there's a freeze on this. So that goes back to June 24th. So from June 24th until now, we have additional protection so that, again, there's essentially a freeze on zoning. Thank you.
Bylaw Committee report. Mr. Crook.
Stephen Crook, Chair of the Bylaw Committee. The Bylaw Committee voted on November 7th, their November 7th meeting, 3-0-0 to recommend this article with one typographical change. On 4.13.2, where it says medial, it should say medical, so that it would read temporary moratorium on medical marijuana treatment centers / registered marijuana dispensaries. That appears on page 11 of the motions to be made at the town meeting. And in the warrant.
Oh, I see him. Yep.
On page 25.
Will the maker of the motion accept that as part of the main motion? Who's? Yes. Is there any objection to that change? None appearing. Thank you. Okay, CPDC report. Mr. Safina.
Thank you, Mr. Moderator. On July 8th, 2013, CPDC convened to hold a public hearing on proposed Article 15 for a moratorium on medical marijuana treatment center registered marijuana dispensaries. Article 15 seeks to include a definition of medical marijuana treatment center registered marijuana dispensary into section 2.0 of the zoning bylaw and add a new section 4.13 to propose a temporary moratorium on these uses through November 2014. The public hearing was held to provide an opportunity for comment and to determine whether the provisions of the proposed Article 15 shall be adopted by the town. The July 8th, 2013, public hearing was opened at approximately 7:30. A presentation was made by the town planner and discussion followed. All comments received at the public hearing were included as part of the record of the hearing. Public hearing was closed that same evening on July 8th, 2013. CPDC voted 5-0-0 to recommend the proposed zoning amendment to town meeting.
Further discussion? Mr. Brown?
Thank you, Mr. Moderator. Bill Brown, Precinct 8. I'd like to move to indefinitely postpone the subject matter.
Is there a second? Second. Mr. Brown?
Thank you, Mr. Moderator. Had we zoned, as I suggested 6 months ago, the industrial zone for this, we wouldn't have to be here tonight. I think the time spent on this temporary thing could have been better spent on a zoning district, period. And I don't see the need of this, and I think it's not needed. Thank you.
Further discussion? Yes, in the back. I cannot. Oh, okay. Mrs. Doctor. Ms. Doctor.
Nancy Doctor, Precinct 1. I'm actually going to vote to support this, not because I oppose of any of the dispensaries, but I actually think the town needs a year to actually examine their anxiety about implementing this law. When I actually picked up my warrant and I actually read the language that was used to support it, I actually thought you could have been talking about opening a methadone or Suboxone clinic here in town, as opposed to a dispensary. I think there's plenty of neighboring towns and cities that are actually implementing the law right now that we should be looking to help guide us. I think Adam Chapdelaine is the town manager of Arlington, and he's actually recommending zoning to restrict the dispensaries to actually all the central retail sections of Arlington. The understanding is that if you zone in a back alley, if you basically are zoning medical marijuana.
Again, I would point out the issue before us is the moratorium.
Yes, so the idea is I think we need to look at other towns and we need to actually use the year to examine what the concerns that we have in a more thoughtful manner, because these dispensaries are not pot shops and the clients are not drug addicts, they're patients. So I actually look forward to spending a year to examine all of this and to look at other towns. Thank you.
Mr. D'Addario.
Ron D'Addario, Precinct 6. Thank you, Mr. Moderator. You know, I'm going to vote for this, but there's just one thing I really need to say, and that is I'm always think about the voting on the referendum, and that Reading voted for this, something like, I don't know if it was 53% or 57%. The state voted for it. So my request is that when the town is doing this annual review, and if they do put together some kind of a group or a committee, that they open that up to people who may be proponents of this, the medical use of marijuana. And I suppose there have to be many if the majority of Readingites of the voters voted for it. So I think in that way, I just want to make sure that we're being fair. I know we're going to give it a good look. But maybe there's the idea that, and maybe it's just me and I apologize for it, but if we're looking for ways to bury it, then that doesn't seem, and I apologize if I'm out of line on that word, but if that shouldn't be the case, if this is what we voted for, whether I'm personally for it or against it or whatever, I think we have to try to make this thing work, and having people who might be proponents have an opportunity, if they wish, to be part of that group, I think would be a good idea. Thank you so much.
Further discussion? Mr. Barnes?
Thank you, Mr. Moderator. Jonathan Barnes, Precinct 5. I too support this. I actually think, not to paraphrase Mr. Brown, I'm not sure I do that often, but I think I actually suggested this 6 months ago as well, but probably for different reasons. And I would also suggest I oppose the motion to indefinitely postpone. It may very well be true that had we supported an earlier motion to locate this or zone this in the industrial district, this wouldn't be necessary, but I don't believe we did support that then, so I think it is necessary. And I also want to support some of the statements made by Mr. Daddario. Actually, both previous speakers. I think it's imperative for a number of reasons that, that during this process we do keep an open mind. I'd actually like to ask, I know the slide presentation referenced the town of Burlington's moratorium. I'm also aware that the town of Burlington has already articulated a very comprehensive review process and program, an open program and a broad program to review the regulations and all affiliated issues related to it. And I assume that this will be reviewed comprehensively by the CPDC and by our selectmen, but I just want to ask or demand, to the extent I can, that that process be very, very open and broad, because I do think this will require substantial understanding of both sides of the issues. And lastly, I agree as well. When I read not so much the motion, but the background, I also thought this was referring to something else. When I read the references to data reflecting higher criminal activity, or when I read the statement in the background that states have seen an increase in traffic accidents and driving under the influence, I might have thought we were talking about liquor stores or bars or restaurants. So I only encourage all of us and all of the town to keep an open mind when we discuss the issues related to this situation. Thank you.
Further discussion? None appearing? Are we ready for the vote? We will first vote on the motion to indefinitely postpone. All those in favor of that motion, please raise your hand. Those opposed? And that motion does not carry. The main motion with the slight amendment from medial to medical is it requires a 2/3 vote. Again, I ask my counters if you can help. All those in favor of the main motion, please rise. (31).
30.
30.
23.
23. 34. And those opposed?
1.
1. 1 and 2? Okay, and you said 1, Phil? Okay, and that was
3.
3. The vote being 118 in the affirmative, 7 in the negative, the motion carries. Mr. Bonazzoli? Is a motion to adjourn sine die. Is there a second? It's non-debatable. All those in favor, please signify by raising your hand. Those opposed, motion carries. This town meeting stands adjourned sine die.